Students are joining. We will start in a minute. Hello, good morning, and welcome to Baiju's Exam Prep. Today is lecture 1 of Indian Polity. In 25 classes, maybe we would need an extra class. So in about 90 hours, we shall be completing the entire syllabus of Indian Polity, both from the prelims as well as the mains perspective. We will start slowly and slowly, we will later pick up pace and complete the syllabus, because the idea is to make every single student understand the nuances of Indian polity. You may not be exposed to Indian polity at all during your graduation or even at school. So my job is to make this subject as simple as possible for you to understand. Clear? That's number one. Number two, throughout this class, you can ask questions. There are 5 subject matter experts, 5 polity experts along with me, who would be able to answer your questions in text format. But if you want me to answer your questions, then you'll have to wait. Wait in the sense, I will first complete a topic, let's say in about 1 hour or 1 hour 15 minutes. Then I will stop. I will start taking your questions. Then we will restart the lecture. But throughout the lecture, if at any point in time you have doubts, we have 5 subject matter experts who will resolve your doubts instantly. Clear? But there are also students who have enrolled with us for our live classroom program, and this may be your first class. So I will first give you a brief introduction of what this course offers you. Number one, this is the year-long timetable. As soon as you enroll, you are given a timetable, whether you have enrolled in the morning batch or the evening batch or the weekend batch. And you would know that you can attend morning, evening, plus the weekend batch, all the 3 batches. But I would suggest stick to one batch and follow the lectures of that particular batch. For example, you have enrolled here, let's say, polity. You have enrolled in these live lectures, although we have replaced polity with modern history. So you have enrolled now. First, we will cover polity. Then we will cover modern history and post-independent India. Then geography, then economics, then environment, then ancient, then international relations. And once the prelims exam is over, then we will be discussing ethics, governance, social issues, social justice, because these are the subjects which are primarily relevant for your mains examination. So please do not worry. Even if you have joined late, in this last batch, we will still be completing the entire syllabus for you. And at the same time, if you have enrolled in the evening batch, in the evening batch also, the entire syllabus would be covered, but there are some mains-based topics which will be covered after the prelims exam is over. Similarly, for the weekend batch as well. Long story short, this is lecture number 1 of Indian Polity. In 25 classes, in about 90 hours, we will complete the entire syllabus. We will start slowly and pick up pace over a period of time. Throughout this lecture, if you have doubts, get in touch with the subject matter experts and they will resolve your doubts. But if you want me to answer those questions, then please type your questions when I'm asking you to ask me questions, which is after we complete a particular topic, which may be 1 hour, 1 hour, 15 minutes. Clear? Now we need to understand, what is this Indian polity? Indian polity is considered to be one of the most important subjects for the civil services examination. And the reason is because I teach this subject. But that's not the reason. The reason is, look at the sheer amount of marks that are allocated to this subject. This subject, Indian polity, is relevant for prelims, relevant for mains, relevant for essay, relevant for the personality test as well, relevant for all the stages of the civil services examination. Look at the data, historical data, right from 2011 till 2023. Sometimes 14, sometimes 15, sometimes 22, sometimes 18 questions have been asked from Indian polity. Let's say 20 questions are asked from Indian polity in your prelims. 20 into 2, 40 marks. And we know that currently the cutoff sometimes ranges 81, 89, 95. If out of 95 marks, 40 marks you can obtain from Indian polity, which means you are one step closer to the mains examination. So why Indian polity is one of the most, not the top subject, but one of the most important subjects is because of its relevance in the prelims examination. Not just prelims, look at the mains examination. If we look at GS paper 2, it talks about polity, governance, it talks about social justice, it talks about international relations. If we exclude social justice, we exclude international relations because that is taught separately. Even governance is taught separately. So here in these 25 classes, we will be focusing only on the Indian polity aspect of GS paper 2. Governance will be dealt separately, international relations separately, social justice separately. But if we strictly look at Indian polity, sometimes 150, sometimes 120 marks are asked from Indian polity out of 250. That makes Indian polity one of the most important subjects for your examinations. But even in essay, even the so-called philosophical topics that are asked in the examination, even there, your knowledge of the law, your knowledge of the constitution, your knowledge of the fundamental rights, your knowledge of the recent Supreme Court judgments, if you incorporate all those points in your essays, you will have an extra edge over others. So Indian polity, which we are discussing now, is one of the most important subjects. Why? Because of the sheer amount of marks that are allocated to the subject, whether it is prelims, whether it is mains, whether it is the essay. And not just that, look at the personality test. Questions are asked of the recent Supreme Court judgments by the interview panel. Questions are asked about the recent political developments that are taking place in our country. Questions are asked of the recent laws that are passed by the parliament or the bills that are pending in the parliament. For example, our students this year were asked about the data protection bill. Our students were asked about those bills which were pending inside the parliament. So your knowledge of Indian polity, which you will gain through these 25 lectures, is going to help you in all the stages of this examination, whether it is prelims or mains or essay or the personality test. And that completes our introduction number 1, which means to tell you how important is Indian polity for the civil services examination. But if it is very important, then we need to understand what exactly do we need to study in Indian polity. Basically, there are 3 areas on which you will have to focus on. Area number 1, constitution. Constitution in the sense, look at the entire constitution, starting with the preamble, then part 1 of the constitution, which is union and its territory, then citizenship, then fundamental rights, then directive principles of state policy, then fundamental duties, then union, then states, union territories, elections, judiciary, panchayati raj institutions, so on and so forth. But look at me carefully. You have to study Constitution of India strictly according to the requirements of this examination. Yes, after attending these lectures, you may feel confident that you can argue your own case before the Supreme Court of India, but that should not be your purpose. After attending these lectures, you may be confident that you can win an argument with an irritating uncle in your neighborhood, but even that should not be your purpose. That should not be the agenda. The primary purpose should be to study the Constitution so that you're able to answer every single question in the examination. Because the idea should only be to qualify the civil services examination. Nothing more, nothing less. Everything else is an added advantage. You may still win a debate competition in your school or a college. You may, you may still win an argument with your uncle. You will still not be able to argue your own case before the Supreme Court because for that the requirements are different. But your primary purpose should be to score maximum so that you're able to qualify the civil services examination in the single attempt. And at the same time, you don't have to read the entire constitution in great detail because you're not here to become lawyers. So for that, what we need to understand the past trend. We need to understand what are the key focus areas of the UPSC. How deep you will have to dig to find out answers to the questions asked by the UPSC. So constitution is one thing that we need to study, but not as a lawyer, as a civil services aspirant, so that you're able to answer every question that is asked in the examination. So first key focus area of Indian polity. If Indian polity is one of the most important subjects for this exam, what do we need to study in Indian polity? First, the constitution, but as a civil services aspirant, not as a lawyer. Second, laws passed by the legislature. For example, Aadhaar was a law passed by the parliament. Citizenship Amendment Act was a law passed by the parliament. Data Protection Act, so many important laws which have been passed by the parliament, that becomes your important subject matter for your civil services examination. But listen to me carefully. So does that mean all laws passed by the parliament, since the parliament was established in India till today, do we have to discuss all those laws, study all those laws? No. All those laws which have been passed by the parliament over the past 1.5 years, or those laws which are in news. Indian polity, what do we study? Constitution, number one. Number two, what do we study? The laws passed by the parliament. But not all the laws which have been passed by the parliament in its entire history. No, only those laws which have been recently passed, which means 1.5 years prior to your prelims examination, or those laws which are in the news. For example, look at today's newspaper. You will read it after the class is over. NewsClick founder has been booked under a very stringent law known as UAPA, Unlawful Activities Prevention Act, which was passed in 1960s, then amended multiple times. Last, it was amended in the year 2019. So this law was not passed over the past 1.5 years. So why do we need to discuss this law? We need to discuss this law because this law was in the news. And a law which is in the news becomes part of your current affairs. And current affairs, you would know, is the most important aspect of this examination. So number one, in Indian polity, we have to focus on the constitution as a civil services aspirant, not as a lawyer. That is very important for you to understand. Second, we'll have to focus on the laws passed by the parliament. And which are these laws? Those laws which have been passed recently, which means 1.5 years ago, or those laws which are in the news. Even if these laws have been passed in 1950s, 60s, 70s, but those laws which are in the news becomes important for your civil services examination. And finally, judicial verdicts. What is Supreme Court going to decide on the petitions challenging the way Article 370 was diluted by the government? How the Supreme Court is going to pronounce the judgment on the validity of Citizenship Amendment Act, whether CAA is constitutional or not. That is something that we will have to study. What did Supreme Court rule on Shabarimala case? Supreme Court said women of all age groups may pray at the Shabarimala temple. Why that judgment? How that judgment was given? That we will have to study. How did the Supreme Court say that this 10% reservation for economically weaker sections of the society is constitutional? That EWS judgment also we have to study. Because look at the questions that are now asked in the mains examination, the trend that we witnessed starting last year. Discuss this topic citing relevant case laws. Answer this question by citing the relevant case laws. So these case laws, these judgments, whether it is the Keshavananda Bharti judgment, whether it is the Golaknath judgment, whether it is the Kolo judgment, whether it is the Bammai judgment, whether it is Nalsa judgment, whether it is Joseph Shine judgment, whether it is another judgment, all these important judgments we will have to discuss, cite in your answers, because that will give more credibility to your answer. Long story short, Indian polity is one of the most important subjects. Why? Because relevant for prelims, mains, essay, personality test. Clear? Done. But what do we study in Indian polity? Three things, three focus areas. One, the Constitution of India. Second, the laws passed by the legislature. And we will discuss what is a legislature, what is executive, what is judiciary. But hold your horses. Third, we will have to discuss various Supreme Court judgments, judicial verdicts. These are the three areas that we will lay our entire emphasis on, which will make you ready for the civil services examination. Is that clear? Let's look at something else. Sir, if Indian polity is one of the most important subjects, and there are three key focus areas on Indian polity, but tell us what are the books that we need to study. There are lots of books available in the market. M. Lakshmikant, D.D. Basu, Subhash Kashyap, V.N. Shukla. Then you have the Bare Act of the Constitution. Then you have portals such as, or websites such as PRS, Legislative Research, IndianQanun.org. Then there are newspapers, the Hindu or Indian Express or Times of India or Hindustan Times. Then, sir, there are these NCERT books. What are the sources that we need to follow for Indian polity? Number one, these classes. These live classes, if you will attend all the 25 lectures, with hand on my heart, you are ready for the exam. Clear? After these live classes, you can go through the annotated PPTs. What are these annotated PPTs? Whatever I'm writing on the screen, all that is going to be delivered to you. So attend the class, go through the annotated PPT. Third, revise from M. Lakshmikant. M. Lakshmikant, don't tell anybody, is one of the worst books written on Indian polity. It has no structure. It has no context. It does not explain why X is X. It is only facts. And all these facts have been collected from various sources by Mr. Lakshmikant, dumped in the form of a bulky book and presented to you. But nevertheless, Lakshmikant is very important for your exam. Why? Because this exam is a three-tier examination system. There is prelims, followed by mains, and then the personality test. In prelims, UPSC will test whether you have the factual knowledge, whether you have the conceptual clarity or not. So questions surrounding concepts, questions surrounding facts will be asked, and the UPSC will judge you whether you're suitable for a career in civil services or not. And how do you get to know these facts? Through Lakshmikant, because Lakshmikant is nothing but the collection of facts, however, necessary for your prelims examination. But listen to me carefully. Lakshmikant will never, ever help you in your mains examination. Never, full stop. Then what do we do for the mains examination? These classes plus Lakshmikant plus newspaper. So does that mean any newspaper? Either of the two newspapers. One, either follow the Hindu or follow Indian Express. These are the two newspapers that you should follow. Ideally both. If you don't have time, there is lack of time, then pick one, either the Hindu or the Indian Express. And ultimately, newspaper plus class lectures plus Lakshmikant put together is going to help you in your mains examination. Because in mains, you would be asked to elaborate on a particular topic. You would need to be analyzing a particular topic, and that will come from current affairs, because mains examination, particularly for GS paper 2, is dominated by current affairs or dominated by analysis that you won't find in Lakshmikant, that you will find in these class lectures plus newspaper, problem solved. But if you have time, please go through these two beautifully written NCERT books, Political Theory and Indian Constitution at Work. It won't take much of your time. One chapter a day over a period of time, you would be able to complete and cover both these NCERTs. But these are beautiful books, beautifully written books, conceptually very strong books written by one of the top experts in this country. Please go through these books if you have time. If you don't have time, in any case, I'm going to cover the important crux of both these books in my live lectures as well. So long story short, let's repeat. Indian polity is one of the most important subjects because it is relevant for prelims, mains, essay, personality test. Done. In Indian polity, we have to focus on constitution, the laws passed by the legislature, and various judicial pronouncements, judicial verdicts. Done. Then what is the source? What is the book list that we need to follow? Class lectures plus annotated PPTs. After this lecture, we also give you something known as ARM to arm you, and that is known as additional reading material. But don't go through that. If you are thorough with the class lectures, if you have understood the class lecture, go through the annotated PPTs. Even after that, if it is not clear, then go through additional reading material, because I don't want to bombard you with content. Then you will only become content collector, not a district collector. So if you want to be a district collector, minimize your sources. Restrict the sources from which you obtain the knowledge. Classes plus Lakshmikant plus newspaper. That should be it. That's your source for Indian polity. And if you have time, go through these two beautifully written NCERT books. Done? Now I will take questions for 5 minutes. After that, we will formally start our lecture. Questions, please. Duration of each class is 3.5 hours. In how many days we will complete the syllabus? We'll be completing the syllabus by, I think, the 7th of November, because the classes are conducted every Monday to Friday. Take a look at 25 classes, and that's the day when the syllabus would be complete. Should we be making notes? Whatever I am saying, you can make note of it, plus whatever is there on the annotated PPT, that should be more than enough. Now let's formally start. And I told you that we will start with basics, assuming you have been you have never been exposed to Indian polity. So you are a complete beginner. You have no idea about Indian polity. Don't worry, we will cover the basics. We'll start from basics, we'll cover from scratch and slowly and gradually build up. If constitution is something that we need to study for Indian polity, the first thing that we need to understand is what is a constitution? What is a constitution? Constitution is, in simple words, a rule book. Rule book in the sense, for example, there is a religion X. For that religion X, there is a textbook. There is a sacred book for that religion. What should the followers of that religion do? That is mentioned in that book. How should their life be governed? That is mentioned in that book. Similarly, replace this individual with the country. How the political setup of the country should be. How this governance of this country should be carried out. That's mentioned in this rule book, and that rule book is the constitution. We can call it a manual as well, in simple words. For example, right now, a kitchen appliance, which is hotly in demand, air fryer, for the healthy individuals or those who want to be healthy because it uses less oil. How to operate that air fryer, we have a manual. Similarly, how to operate a country, we need a manual, and that manual is the constitution. But that was a simplistic definition of what a constitution is. Let's now get into the technicality. We say constitution is the supreme law of land which enjoys special legal sanctity. Constitution is the supreme law of land which enjoys special legal sanctity. What does that mean? We have a hierarchy. At the top of the hierarchy, we have the constitution, followed by the laws passed by the parliament, followed by rules issued by the executive. What is a legislature? What is an executive? We will discuss in great detail later, but very briefly here so that you're able to understand. Legislature is a body which is responsible for making laws. For example, all the MPs that you see in the parliament is a legislature. What is the job of these MPs? To come together and pass laws for the entire country. So the job of the legislature is to make laws. But now the law has been made. Who will implement this law? That implementation will be done by the executive. Who is part of the executive? Prime Minister at the central level, ministers at the central level. For example, a law has been laid down by the parliament, but who will implement this law? Who will construct roads and railways in this country? The central government. And all those ministers, prime minister at the central level, they are part of the executive. There is a hierarchy. What is the hierarchy? At the top of the hierarchy, we have the constitution, followed by the laws passed by the parliament, followed by the rules issued by the executive. How? Listen to me carefully. For example, you want to write something, but you want to easily change this writing as well. You want to modify what you have written as well. What will you do? You will write on a piece of paper with a pencil. You don't like the writing, you don't like the context, what you're writing, you can easily use the eraser and erase what you have written. So something that you write on a piece of paper with your pencil, which you can easily erase, we can call this a law. Law passed by the parliament. How? Because a law passed by the parliament can be changed by simple majority. Simple majority in the sense, easily. Easily in the sense, if there are 500 people in the parliament, let's assume there are 500 members of the parliament, and there is a law to be passed by the parliament. Ordinary law. What we call an ordinary law. What is an ordinary law? Something which is not a constitutional amendment. To amend the constitution, you need a tougher law. You need 2/3 majority, which we will discuss later. But to modify or to pass an ordinary law, for example, Citizenship Amendment Act was an ordinary law. It is not yet part of the constitution. It is an ordinary law passed by the legislature, passed by the parliament. Aadhaar is an ordinary law. Clear? And to modify or pass this ordinary law, you need a simple majority. And what is simple majority? More than half of the members present and voting. If 500 is the number of MPs who are present in the parliament, out of these, only 400 are voting. There are 500 MPs in the parliament. Out of these 500 MPs, 100 they abstain. They are neither voting in favor of this law nor are they voting against this law. They are simply abstaining. They don't want to vote. 400 are voting. Simple majority becomes 201. More than half of the members present and voting. Which means to change this ordinary law, to pass this ordinary law, you need a simple majority. You can easily change a law, you can easily delete a law, you can easily pass a law. Just like you're writing on the piece of paper with your pencil, which you can easily change, alter, modify, delete. But something which is there in the constitution, it becomes difficult to change. It's like you're writing something on a board with a permanent marker. Even the writings of this permanent marker you can change. But for that, you need a tougher substance to erase that writing. And that is what we call constitution. That is why only those things should be mentioned in the constitution where you have the idea that this is something that should continue for another century. For example, fundamental rights, directive principles of state policy, the role and the powers of the president, which we want to continue for a long time, as long as we have the Union of India, as long as we have the idea of India. For those, we mention it in the constitution. So if at all we need to create a hierarchy, for example, in organizations, we have the chief executive officer, then we have the chief operating officers, then we have the presidents, then we have the vice presidents, then we have the assistant vice presidents, go down to the lower level. There is a hierarchy. For the laws, do we have a hierarchy? Yes. At the top of the hierarchy is the constitution. Just below the constitution are the laws passed by the legislature. And just below those laws are the rules issued by the executive. What are these rules? Let me make it simple. Citizenship Amendment Act was passed in the year 2019. What was that Citizenship Amendment Act? That now those migrants, which we will discuss in great detail in citizenship chapter, but very briefly here so that you understand. Citizenship Amendment Act was passed in 2019. What does the law say? That all the migrants who have come from Pakistan, Afghanistan, Bangladesh, and if they have entered India on or before 31st December 2014, we will grant them citizenship. That's what the law says. But to implement this law, I told you laws are passed by the legislature. Laws are implemented by the executive. And how this law will be implemented, for that rules should be made by the executive. What are these rules? Law only says that if you have come from Pakistan, Afghanistan, Bangladesh, and if you have entered India, we will give you citizenship. But rules should be made so that we can judge, we can test, we can be sure that these individuals have come from Pakistan, Afghanistan, Bangladesh, not from any other country. For that, rules are to be made. Rules are to be made by the executive. Law says you should have entered India on or before 31st December 2014. But rules should be made so that we can be sure that only those who have entered before 2014 December, they should be given citizenship. These rules are made by the executive. So constitution, the supreme law of land, followed by the laws passed by the legislature, followed by the rules issued by the executive. Clear? And we say constitution is the supreme law of land, which means at the top of the hierarchy, we have the constitution. But not just that. Constitution is the supreme law of land, which enjoys special legal sanctity. And what is that special legal sanctity? Can the rules issued by the executive violate the constitution? No. Can the laws passed by the parliament violate the constitution? No. That means every rule that executive is making has to conform to the constitution, has to be in agreement with the constitution, has to be in conformity with the constitution. Every law that is passed by the parliament cannot go against the spirit of the constitution. And if it is, then this law shall be struck down by the judiciary. This law can be declared unconstitutional by the judiciary, and after that, this law will not come into force. An example. The year was 2000. The most classic example to understand what do we mean by this term, constitution is the supreme law of land. Information Technology Act was passed in the year 2000. But this Information Technology Act was amended in 2008. Amended in the sense this law was modified in 2008. Some more sections were added to this law in 2008. That's what we call amendment. And this amendment, Section 66 capital A, was added to this Information Technology Act of 2000, which means Information Technology Act was passed in the year 2000. But in 2008, a need was felt to modify this law, to change this law, to amend this law. And that's how in 2008, Section 66 capital A was added to Information Technology Act. And what is this law? This law is not there in the Constitution. Why? Because this law would need to be changed over a period of time. This is like you're writing on a piece of paper with a pencil, which you can easily change, modify, amend. If this law would have been in the Constitution, it would have been like marking with a permanent marker on a board, which becomes very difficult to change. That is why not all laws are there in the Constitution. So this is the law which was passed by legislature, the Parliament of India. But we know every law passed by the Parliament has to be in agreement with the Constitution. Any law which is not in agreement with the Constitution shall be declared unconstitutional by the judiciary. Because of this Section 66 capital A, what was the wording of this section? This section said, if you are using an electronic device, whether it is your smartphone, whether it is your laptop, whether it's your desktop, and you are transmitting messages, these messages cause annoyance to somebody, then you will be booked under Section 66 capital A. Simple. Section 66 capital A, if somebody is using an electronic device, let's say a smartphone or a laptop, and is transmitting messages, Facebook post, Twitter tweet, or now it is known as x.com, whatever, thanks to Elon Musk. If you are posting something on your WhatsApp, whatever you are doing, but if those messages cause annoyance to somebody, you will be booked and you will be sent to jail. Then what happened? Balasaheb Thackeray, the supremo of the Shiv Sena. Now Shiv Sena has been split. 1966, Balasaheb Thackeray, who was a cartoonist, he started this political party known as the Shiv Sena. And then few years ago, Mr. Balasaheb Thackeray passed away. And then the members of the Shiv Sena, the workers of the Shiv Sena, they enforced Bandh in Maharashtra, in the entire state, as a mark of respect to their departed leader. One lady, Shaheen Darda, she posted on her Facebook, Mr. Balasaheb Thackeray has passed away, has died, but what is the reason, what is the need to enforce Bandh in the entire state? One of her friend liked her Facebook post. Both were arrested. Why? Because of violating Section 66 capital A. And what is Section 66 capital A? If you use an electronic device, they use their phone to transmit a message, Facebook message, which causes annoyance to somebody, caused annoyance to the members of the Shiv Sena. How dare you question our Bandh in praise of our departed leader, beloved leader? You have offended us, you have annoyed us. An FIR was filed, Shaheen Darda and her friend were arrested. Another case. One businessman in Puducherry, he logged in to his Twitter account, it was then Twitter, posted a tweet and said the then finance minister, Mr. P. Chidambaram's son, has amassed huge wealth. Caused annoyance to Mr. Karti Chidambaram, who is now the member of the parliament from Shivaganga constituency in Tamil Nadu. Caused annoyance to him. This particular businessman from Puducherry was arrested under Section 66 capital A. One law student, Shreya Singhal, she approached the Supreme Court. My lord, do we have fundamental rights? Court said, obviously, Ms. Shreya Singhal, you have fundamental rights. My lord, Constitution of India, in part 3 of the Constitution, which deals with fundamental rights, talks about Article 19, Clause 1, Clause A. Said yes. And this fundamental right talks about freedom of speech and expression. What is this fundamental right? Say whatever you want to say. Express whatever you want to express without inciting violence, without causing violence. Say whatever you want to say. That is your fundamental right. Ms. Shreya Singhal said, this Section 66 capital A violates Article 19, 1A of the Constitution, which is a fundamental right. And since Constitution is the supreme law of land, which enjoys special legal sanctity, which means no rule issued by the executive, no law passed by the parliament can violate the Constitution. My lord, this Section 66 capital A, which is a law passed by the legislature, violates the fundamental right provided by the Constitution. Supreme Court said you're absolutely right. This Section 66 capital A is unconstitutional. And that is what I say. Constitution is the supreme law of land, which enjoys special legal sanctity, which means any law passed by the parliament has to be in agreement with the constitution. Any rule issued by the executive has to be in agreement with the constitution. If any law is passed by the parliament, any rule is issued by the executive which violates the constitution, then that law, that rule shall be declared unconstitutional by the judiciary. That is why there are cases which are filed in the courts that this particular law passed by the parliament is unconstitutional. That law is challenged. And then the Supreme Court has to decide whether this law violates the constitution or not. If it violates the constitution, then that law will not enter into force. But constitution is something else as well. Vast majority of the countries of the world, they need a rule book as to how their country should be governed. Governed in the sense, United States is a presidential democracy. Presidential democracy in the sense the real power is with the President of the United States of America. But India is a parliamentary democracy where the real power is with the Prime Minister. We have a president as well, but the real power is with the Prime Minister. How should a particular country's polity be governed? What should be the role of the president? What should be the role of the Prime Minister? What should be the role of the judiciary? What should be the role of the Election Commission? For example, 2024 elections will be conducted by the Election Commission of India. Does that mean 2029 elections will be conducted by Byju's? Or 2034 elections will be conducted by some other institution, for example, the CAG or UPSC? No, there will be one body, Election Commission of India, whose job is to conduct elections, all elections in India, whether parliamentary elections or legislative assembly elections. So there has to be some rule book which will govern this country. What should be the job of the legislature? What should be the job of the executive? What should be the job of the judiciary? What should be their areas of influence? All that is mentioned in this constitution. Fundamental principles on which the country's governance is based on. That is mentioned in the constitution. But constitution not only talks about the form of government that we will have. It doesn't only talk about what are the roles and responsibilities of each organs of the state. Legislature, executive, judiciary, these are the three organs of the state. Constitution also talks about the rights that you and me as citizens enjoy, which nobody can snatch from us. You and me have the right to life. You and me have the right to equality. You and me have the right against discrimination. You and me have the right to freedom of speech and expression. All these rights are mentioned in the Constitution. That is another job of the Constitution. And all these things cannot be unilaterally changed by an ordinary legislative act. And what is this ordinary legislative act? Something I told you, an ordinary law. Ordinary law in the sense, something that you write on a piece of paper with pencil, which you can easily change, modify, amend. But constitution is something which cannot be changed by simple majority. Constitution can be changed by a special majority, which means you need the majority of 2/3 members of the parliament. If there is something, let's say, for example, there are 1,000 students in the class, for example. Sir, we need a break. For example, you're telling me, sir, we need a break. It is too much to process right now. Give us the break. I'll say, let's go by the majority. If 501 students say, give us the break, I'll say, okay, I'll give the break because that's the majority. What is majority? Half. 1,000 is the student count. 501 say, give us the break, I have to give the break. But if I want taking breaks slightly difficult, I will say I will not follow the simple majority, I will follow special majority. Which means 751 students, if they say give us the break, only then I will give you a break. And that is slightly difficult to obtain. Because then 2/3 of the students should say, sir, please give us the break. That's the same case with the Constitution. If Constitution is to be changed, all those who are present in the parliament, 2/3 members will have to say, yes, we want to change the Constitution. If you don't get 2/3 majority in the parliament, you cannot touch the Constitution. You cannot change the Constitution. And that is why we say, this is a higher law. What is a higher law? This Constitution, which talks about what is the role of the three organs of the state, legislature, executive, judiciary, which talks about the fundamental rights that are available to the citizens. This law is placed at a higher law, which cannot be changed through an ordinary legislative process. And this higher law is the Constitution. So long story short, what is a constitution? We say the vast majority of contemporary constitutions describe the basic principles of the state. Basic principle of the state: are we an Islamic state or a secular state? Are we a Hindu Rashtra or a secular state? That's mentioned in the Constitution. Preamble. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic. All these are the basic principles defined in the Constitution. Structures that we need to follow, whether a parliamentary democracy or a presidential democracy. Processes of government. What should be the role of the president? What should be the role of the prime minister? The fundamental rights of the citizens. Where are these mentioned in the Constitution? All these things are mentioned in the Constitution. And this Constitution is placed at a higher level. This is a higher law. That's why I say Constitution is the supreme law of land. And the supreme law cannot be changed, cannot be unilaterally altered, modified, amended through an ordinary process. For that, you need a difficult process, which means 2/3 majority. And this higher law is the Constitution. That is what a constitution is. Any questions as of now? No question. Clear. Okay. Great. Now, when we have discussed what is a constitution, there are some different types of constitutions that we see in different parts of the world. We don't have to go too deep into these types, but just for the sake of understanding, we need to differentiate between two types of the constitutions. One, constitution can be written, or constitution can be unwritten. What is a written constitution? For example, if you were to ask me, sir, show me the Constitution of India, I will take out this bulky book and tell you this is the Constitution of India with 12 schedules, 25 parts, 445 articles. This is the Constitution of India. Sir, show me the Constitution of United States. I will take out a small pamphlet and tell you this is the Constitution of United States with 27 amendments since 1789. That means this Constitution is written. Written means Constitution is codified. Codified into parts. For example, our Constitution starts with a preamble. Then there is part 1 of the Constitution, which deals with union and its territory. Part 2, which deals with citizenship. Part 3, which deals with fundamental rights. Part 4 deals with directive principles of state policy. Part 4, capital A, deals with fundamental duties, so on and so forth. We have 25 parts. That means our entire Constitution is what? Written. Written means it is codified into various parts. Part 1, Part 2 till Part 25. Similarly, US Constitution is also codified. Article 1 of the Constitution of United States gives all the powers to the Congress of United States. This is not Rahul Gandhi's Congress. The Parliament of United States is known as the US Congress. And US Congress is bicameral. Bicameral in the sense, it has two houses. One is House of Representatives. The other is Senate. Just like in India, we have a bicameral legislature at the central level. The Parliament of India consists of two houses. Lower house known as Lok Sabha or House of the People. Other house, which is the upper house or House of Elders, known as Rajya Sabha or Council of States. Why it is known as lower house, why that is known as upper house, we will discuss that in Parliament chapter. But here, similar to India, US Parliament is also, which is known as US Congress, it is also bicameral. One house is known as House of Representatives, the other house is known as the Senate. All the legislative powers are given to this Congress. That means who will make law for the United States? This US Congress. All executive powers under Article 2 of US Constitution are given to the President of the United States of America, who may not have complete cognitive sense, but be that as it may. Article 3 of the US Constitution says all the judicial powers are given to the Federal Supreme Court. That means Article 123 of US Constitution clearly talks about powers given to legislature, executive, judiciary. That means laws are written and codified into various parts. But then there are some countries, for example, England, for example, New Zealand, where we follow an unwritten constitution. Unwritten constitution means not all laws are written, conventions play a very important role, and parliament is sovereign. Listen to me carefully. What is a constitution? Do you know that? Constitution is the supreme law of land which enjoys special legal sanctity. We can say constitution is a document of people's faith and aspirations. For example, when we were under the colonial rule, we desperately wanted dignity. We desperately wanted equality. For example, there was a time when an Indian judge cannot try Europeans. If there is a judge who is a localite, who is from India, sorry, but the accused is a European, this Indian judge cannot try a European because there was no equality. We were begging for equality. We were begging for justice. We were begging that we should pass our own laws for the people of India, but we were not given these rights. But then came independence. We had a body known as the Constituent Assembly, a body of Indians who were then tasked, responsible to draft the Constitution of India. Spectacular work was done by Dr. B.R. Ambedkar, and we gave ourselves a constitution. And now this constitution talks about equality. This constitution talks about justice. This constitution talks about liberty. That means whatever our aspirations were, these aspirations were documented in this beautiful document known as the Constitution. So Constitution is not only a supreme law of land which enjoys special legal sanctity. Constitution is not only that higher law which cannot be changed through an ordinary law. Constitution is not only that document which tells us what is the job of the legislature, executive, judiciary. Constitution is not that only document which talks about the fundamental rights of the citizens. Constitution is not only that document which talks about the structures of government. Constitution is that document which is the reflection of people's faith, people's aspirations. But this constitution can either be written or unwritten. Written constitution in the sense, Indian Constitution, United States Constitution, whatever is there in the Constitution is written, presented to you in the form of a book or in the form of a pamphlet. This is the Indian Constitution, this is the US Constitution. But constitutions can also be unwritten. Unwritten in the sense, not all laws are written. Unwritten in the sense, conventions play a very important role. Unwritten in the sense, parliament is sovereign. What does that mean? I told you, if you were to ask me, sir, show me the Constitution of India, I'll take out a bulky book and tell you this is the Indian Constitution. But if you were to ask me, sir, show me the Constitution of United Kingdom, New Zealand, I cannot show you. Why? Because it is not written and codified into one single document. Uncodified into one single document. There is no single document that we can call the Constitution of Britain, Constitution of New Zealand. Why? Sir, does that mean these English people were lazy? They could not take all the laws and consolidate them together in the form of a single document. Were they lazy? Perhaps. Or just like two individuals are not alike, two countries also cannot be alike. Different. Throughout the history of United Kingdom or England, They never felt the need that all these different laws that we have, for example, laws related to Prime Minister, laws related to the people of England, their rights, laws related to the judiciary, they never felt the need that we need to bring all these laws together and document them into one single document. They never felt the need. If tomorrow they will feel the need, maybe they will also write their constitution. Write the constitution in the sense that doesn't mean laws are not written. Laws are written. But laws are written, they are not codified into one single document. In India and United States, laws are written and codified into one single document. This one single book, one single document is the Constitution of India, Constitution of United States. But in England, although laws are written, not all laws, I'll tell you later why, but laws are written, but they're not written and codified into one single document. They're not presented in the form of a single document. Why? Because they never felt the need. For centuries, they have been governed like this. They never felt the need that we need all these laws to be documented into a single document. If tomorrow they will feel the need, maybe they will consolidate all their laws into one single document known as the Constitution. Which means when not all laws are written, conventions play a very important role. What is a convention? An unwritten rule. What is an unwritten rule? Listen to me carefully. The Queen of England, or now we have a king, the King of England, when British Parliament passes a law, passes a bill. What is a bill? Bill is a proposal. What is the proposal? Let's say the proposal is universal basic income. All the people of India, regardless of their income, regardless of their educational qualification, regardless of their resources, we will give them 3,000 rupees per month. That means 3,000 rupees is what? Basic income. Universally given to everybody, from Ambani to a sweeper. Everybody will be given 3,000 rupees per month. That is universal basic income. Let's say this is something that is to be implemented in India. This bill will be passed by both houses of the parliament. Then it will be sent to the president. Prime Minister will tell the president, please sign this. President will say, okay, I'll sign this. Once the president signs this, this bill will be implemented. This proposal will be implemented. That means this bill becomes an act. It becomes the law of the land. But sometimes the president may say, I'm not going to sign this bill. Has it happened? It has happened. I'll give you a few examples later. But one example here. The year was 2006. A bill was passed by both houses of the Indian Parliament known as Office of Profit Bill. We will discuss in Parliament chapter what is this Office of Profit. But a bill was passed by both houses of the Parliament. I'll give you a brief background as well. Srimati Sonia Gandhi, she was the member of the Parliament, Lok Sabha, from the Rai Bareilly constituency of Uttar Pradesh. She was also the chairperson of the National Advisory Council, NAC. The question came that as the member of the Parliament, you cannot hold any other post. Since you are holding other post, which is of National Advisory Council chairperson, you are holding an office of profit. And as such, you should be disqualified. Srimati Sonia Gandhi resigned. She contested the election again, and this time won by a thumping majority. But she wanted again to become the chairperson of the National Advisory Council. What the members of the Parliament of her party decided? They said this post, chairperson of the National Advisory Council, should be kept under the exempted list. Exempted list in the sense that they should declare that this post of National Advisory Council is not an office of profit. When it is not an office of profit, which means you cannot be disqualified. A member of the Parliament, even after you have become the member of the Parliament, you can still be disqualified. Disqualified means you will no longer continue as the member of the Parliament. For example, Shri Rahul Gandhi, till recently, he was a member of the Parliament, but he was convicted by a court, given sentence of 2 years in jail for criminal defamation. He lost his membership. Luckily, Supreme Court came to his rescue. Supreme Court said, no, this conviction is suspended, and then he was reinstated as the member of the Parliament. But even after you are the member of the Parliament, you can still lose your membership if you have been convicted, if your citizenship has got changed. For example, to contest election, I should be an Indian. I contested the election as an Indian, got admitted, elected to the Parliament of India. But after that, I gave up my citizenship. I took up Canadian citizenship, reverse Akshay Kumar. Does that mean as a Canadian, I can continue as the member of the parliament? No, I will lose my membership if my citizenship has got changed. Similarly, after my election, if I'm holding an office of profit, I should be disqualified. Sonia Gandhi, as the member of the Lok Sabha, she was the chairperson of the National Advisory Council. That means as the member of the parliament, she was holding an office under the executive, under the government, which violates office of profit. She resigned, contested the election again, and the parliament meanwhile decides that this National Advisory Council post, chairperson, should be kept in the exemption list. That means this position should be exempted from office of profit. Even if you are holding this office, it should not be declared you are holding an office of profit. That means you will not be disqualified. When this bill was passed by both houses of the parliament, because Congress then had the majority, APJ Abdul Kalam was the president of India. This bill, Office of Profit Bill, was presented to Mr. APJ Abdul Kalam. And he said, I'm not going to sign this. He sent the bill back to the parliament. Please reconsider this bill. The very next day, Indian Express said, this is UPA government's oops movement. They passed, parliament passed, both houses of the parliament passed this bill, sent to the president. President refused to sign this, saying, please reconsider this bill, sent the bill back for parliament to reconsider. And Indian Express said, this is the Congress government's oops movement. Oops, the president has sent the bill back. That is mentioned in the constitution because president can give his signature on the bill, may say, I'm not going to sign this bill, may send the bill back for reconsideration, saying, please reconsider this bill. This is mentioned where? In the constitution. But in England, there is a convention. And what is that convention? Unwritten rule. A rule that they follow, but which is not mentioned anywhere. And what is that rule? The king has to sign the bill passed by the Parliament of Britain. When the Parliament of Britain passes any bill, it is sent to the king or the queen, as it may be. They have no other option but to sign that bill. Is it mentioned anywhere? No. Is it mentioned in any law? No. Where is it mentioned? It is unwritten rule. And that unwritten rule is the convention. Not just this. In India, Lok Sabha can be dissolved. Who can dissolve Lok Sabha? President of India. But how? On the advice of the Prime Minister. For example, 1971, after the India-Pakistan war, which led to the emergence of Bangladesh as an independent country, Srimati Indira Gandhi was the Prime Minister. She said, now the public mood is in my favor. I lost a few elections previously, but now the public mood is in my favor because I have divided Pakistan, split Pakistan, and led to the creation of an independent country. Previously, she was known as Gungi Gudia because when Pandit Nehru passed away, then Lal Bahadur Shastri became the Prime Minister. After the unfortunate death of Lal Bahadur Shastri at Tashkent, then the debate was who will become the Prime Minister. Morarji Desai said, I should become the Prime Minister because I'm the senior most member of the parliament or of the Congress party. Some members of the Congress said, no, Srimati Indira Gandhi should become the Prime Minister. Morarji Desai and some other members said, how can Indira Gandhi become the Prime Minister? She is Gungi Gudia. She can't speak. She is like a doll who can't speak. But then this Gungi Gudia became Durga in 1971 when she dismembered Pakistan, split Pakistan, which led to the emergence of Bangladesh. And then she asked the president, dissolve Lok Sabha. Dissolve Lok Sabha so that we can have fresh elections. And when we will have fresh elections, public mood is in my favor. I will get more members of my party elected to Lok Sabha. But this is mentioned in the constitution. On the advice of the Prime Minister, the president can dissolve the Lok Sabha. Is it mentioned in the UK constitution? Is it mentioned in any law in United Kingdom that the king can dissolve the lower house of British Parliament, which is known as the House of Commons? No. But the king can dissolve the lower house of British Parliament only on the advice of the Prime Minister. This is not mentioned anywhere. This is an unwritten rule. This is the convention. So in a written constitution, whatever is there in the constitution, follow that. That is the constitution. But in an unwritten constitution, there are some unwritten rules known as conventions, which are treated as if they are part of the constitution. And this, in an unwritten constitution, Parliament is sovereign. Parliament is sovereign in the sense, listen to me carefully. Here is Indian Parliament. And here it is the British Parliament. What do we mean by sovereignty? In the sense, the ultimate power to make any decision, to unmake any decision. That is sovereignty, independence. Independent power to take any decision, to make any decision, to unmake any decision, that is sovereignty. Indian Parliament has some restrictions. What are the restrictions? Can you tell me what are the restrictions on Indian Parliament? Indian Parliament can make laws. British Parliament can also make laws. But in Indian case, Indian Parliament has got some restrictions. What are these restrictions? Constitution is a restriction. Have Constitution? Parliament of India pass any law, but it has to be in agreement with the Constitution. Pass any law, but it should not violate fundamental rights. So there is a restriction. So can we say Indian Parliament is sovereign? No. Why? Because sovereignty means take any decision, make any decision, unmake any decision without any restriction. But Indian Parliament has got restrictions. Not just that, there is something known as doctrine of basic structure. What is basic structure doctrine? Innovated by the Supreme Court in a landmark Keshavananda Bharti case. Keshavananda Bharti case, which we will discuss later when we will discuss amendment of the Constitution and the doctrine of basic structure. But very briefly here, the original Constitution, when it was written in 1950, it did not place any restriction on the Parliament. The only restriction was that a law which is passed by the Parliament should not violate fundamental rights. That's it. There was no other restriction. When there was no other restriction, various changes were made by the Parliament and ultimately matter went to the court. And now the court had to answer this very basic question. Is the power of the Parliament supreme that it can amend any provision of the Constitution? The Supreme Court said no. Parliament has the power to amend any provision of the Constitution, but it does not have the power to alter the basic structure. For example, this is a building. Clear? This is a building. Can we change this screen on which I'm writing? Yes, we can. Can we change this mic from which you can hear me? Yes, we can. Can we change the lighting of this place? Yes, we can. Can we change the air conditioner? Yes, we can. Can we change the teacher? Yes, we can. But can we change the very foundation of this building on which this building is standing? Can we? We can. But for that, you have to demolish this building and then create another building, which is not the same as the current building. Similarly, there are some things in the Constitution which you can change. But there are some building blocks on which this Constitution rests. Those you cannot alter. For example, parliamentary democracy is part of the basic structure. Rule of law is part of the basic structure. Secularism is part of the basic structure. Independence of judiciary is part of the basic structure. Objectives mentioned in the preamble are part of the basic structure. All these cannot be changed by the Parliament, cannot be amended by the Parliament, which means Indian Parliament has got restrictions. Can we say Indian Parliament is sovereign? No, because it has restrictions. It cannot pass a law which violates fundamental rights. It cannot pass a law which violates Constitution. It cannot pass a law which violates the basic structure of Indian Constitution. But when it comes to the British Parliament, it can do anything. It can do anything. It can pass a law, it can repeal a law. It can give some rights to the British people, it can snatch those rights. It can do anything. And that is what one constitutional expert, Dean Lolme, writes about the British Parliament, that British Parliament can do anything except convert a man into a woman and a woman into a man. British Parliament has got no restrictions whatsoever. It can pass any law, it can repeal any law, it can do anything except convert a man into a woman and a woman into a man, according to D. Lolme. Which means British Parliament is what? It is sovereign. which means the parliament, the legislature of a country where the constitution is unwritten, there the parliament is sovereign. In India, parliament is not sovereign. What is sovereign? Constitution is sovereign. That's the difference between the two constitutions, written and unwritten constitution. What is a written constitution? Laws are written, codified into one single document. For example, India, for example, United States. But in an unwritten constitution, not all laws are written, because there are some unwritten rules as well, known as conventions. And in an unwritten constitution, the parliament is sovereign. It can do anything. In the words of D. Lolme, except convert a man into a woman and a woman into a man. Clear? But there is one important category of constitutions that we have to discuss. Whether a constitution is unitary or whether a constitution is federal. You may be hearing these stories about chief ministers of opposition ruled states saying that federalism is violated by the central government. The BJP's government is anti-federalism. What is unitary? What is federal? That is something that we will have to study now. But maybe we will take a break. Yes, no. Students are saying, no, sir, please continue. What should I do? Majority say no. No break, no break, no break, break, no. Okay, no break. By special majority, students have refused a break. And we will continue. What is a unitary constitution? What is a federal constitution? Unitary constitution, for example, South Africa. Unitary constitution, such as the example that we gave now, England, or the British Constitution. What does that mean? Let's say, for example, here is a country. And at the central level, you have the capital. You will better understand this if I give you the Indian example. Indian example in the sense, you're all aware of what is happening in India. India is a country. We have 28 states. We have 8 union territories. Why do we have union territories? What is their role? We will discuss that separately. Let's assume that we have 28 states. In all these 28 states, we have the legislative assemblies as well, which means the Indian Parliament at the center, in the capital, New Delhi, makes laws for the entire country, right? But there are some powers which are given to the states. For example, Indian Parliament can make law on currency, on defense, on external affairs, on banking, on insurance, on citizenship. But the state legislatures, they are also given their own powers. A Karnataka legislature can make law on land of Karnataka, police of Karnataka, law and order of Karnataka, gambling in Goa, the Goa Legislative Assembly, which basically means that powers are somewhere distributed. Some powers are given to the center, some powers are given to the states. Let's assume for a while that all these 28 states are present in India. But it is only the Indian Parliament which is making laws for the entire country, including law and order, including police, including land, including agriculture, including gambling. That means India is a unitary polity. Indian constitution is unitary. If this is a hypothetical situation, if the Constitution of India would have mentioned that the Parliament of India, which is there in the capital Delhi, can make law for the entire country, that means Indian constitution is unitary. Which means there is no Mamta Didi, there is no Siddaramaya, there is no Stalin, which means no Sanatan Dharm controversy either. Which means then all the powers would be there with the Prime Minister at the central level and the ministers at the central level. If such a situation would have existed, such a situation would have meant Indian constitution is unitary. But maybe states are present. Maybe Karnataka is there, Goa is there, Madhya Pradesh is there, Chhattisgarh is there. All these states are present and they can make laws as well. But those are only delegation, not distribution. What is the difference between delegation and distribution? For example, it is my job to come to the studio, to turn on the lights, turn on the camera, turn on the app, turn on this device on which I'm writing. It is my job. But would it be possible for me to do all these things on a daily basis for the entire 25 days of our classes? Maybe not. So I will get somebody. You take care of the camera and the AC. Somebody else, please come. You take care of the screen, this screen on which I'm writing, this stylus through which I write. Another person, come here. You take care of my food. Ensure that I have continuous supply of water, and after the class is over, I have a sumptuous breakfast as well. So what am I doing? I'm delegating the powers, delegating the responsibilities. This is your responsibility, this is your responsibility, this is your responsibility. But at any point in time, I can snatch these responsibilities. I'll say, I don't need these 3 people at all. I will take care of everything. This is known as delegation. Delegation in the sense, maybe the central government at the capital in Delhi, maybe Delhi would set up Karnataka, Chhattisgarh, Tamil Nadu, Karnataka. You make laws on law and order, on land, on agriculture, on police. This is your responsibility. The real power is with me, but I'm just delegating these powers to you. Some of my powers I'm giving to you, but at any point in time, I can snatch these powers, or I can give these powers to someone else. This is known as delegation of powers. In a unitary constitution, powers are delegated, not distributed. Delegated in the sense that the ultimate power is with the center. All powers are with the center. Whether legislative powers, whether administrative powers, whether executive powers, every single power is with the center. That doesn't mean there are no local governments. That doesn't mean there are no states. There may be states. But the states are established or dissolved basis the discretion of the capital. At any point in time, these states can be created, states can be abolished. Who has that power? This capital. And such a constitution which allows this is known as a unitary constitution. England is an example of a unitary constitution. South Africa is an example of a unitary constitution. Now somebody would come up and says, but sir, in South Africa, there are 3 capitals. Which capital has the most power? Doesn't matter whether there are 3 capitals or not. Whether there is a legislative capital somewhere, where the parliament is, where the secretariat is somewhere else, where judiciary is somewhere else. But these are all under center. Center has all the powers, not the states. Such a constitution which allows this is known as a unitary constitution. Long story short, what is a unitary constitution? A unitary constitution is one where all powers are concentrated in one strong center, the capital. And all these powers may be delegated. And delegation is done for administrative convenience. Administrative convenience in the sense, if I get up early in the morning, I drive to the studio, to the office, sometimes I will be late. So I may come here at exact 6 o'clock. And then I will have to turn on the camera, turn on the AC, turn on the lights, turn on the system. It will take some time. It will take 15 minutes. And ultimately, who will be at loss? The students. So for convenience, I can come at my own time. I will reach here by 5:45, for example, or 5:55, for example, and then quickly get started with the class because every setup is ready. For this convenience, I have got 3 people. Similarly, in a unitary constitution, all the powers are concentrated in one strong center. But these powers can be delegated to others for convenience. Because if for a particular state, even the police has to be taken care of by the center, it will be time consuming. For better administration, we will delegate the power of the police to a local state, to a state government. But at any point in time, I can snatch these powers back, take away these powers, because these powers are only delegated. These are not distributed. That's a unitary constitution. But then the constitution can also be federal. Now listen to me carefully, the most important discussion. Constitution can also be federal. But what is the definition of a federal constitution? We don't know. Sir, what is the definition of a unitary constitution? A unitary constitution is one where all the powers, whether legislative, executive, administrative, are concentrated in one strong center, where powers may be delegated for administrative convenience, but the powers are not distributed. Such a polity is known as a unitary polity. Such a constitution which allows this is known as a unitary constitution. For example, South Africa, for example, Britain. But what is the definition of a federal constitution? We do not know. There is no definition. When there is no definition, then what do? We take a look at the US Constitution. Which is considered to be the oldest federal constitution of the world. Indian Constitution, is it unitary or federal? Japanese Constitution, French Constitution, Australian Constitution, Irish Constitution, Russian Constitution, are these constitutions unitary or federal? If this definition is matching, then they are a unitary constitution. But are they federal or not? We don't have a definition of a federal constitution. Then is Indian Constitution unitary or federal? We match it with the US Constitution. If it matches with the US Constitution, it is federal. If it doesn't, then it is something else. But what are those characteristics? What are those features which make US Constitution a federal constitution? 5. There are 5 important characteristics in a US Constitution which makes it a federal constitution. Which are these 5 characteristics? Number 1, written constitution. Constitution has to be written. It cannot be unwritten like Britain. It has to be a written constitution. Not just that, dual government. What is dual government? One government at the center headed by Joe Biden, but every single state in the United States, and there are 50 states in the United States, they have their own governments as well. Dual government. One government at the center, one government in the state. Not just that, power should be distributed. Distribution of powers. Some powers are given to the center, some powers given to the states. It is not delegation, because delegation is done by a superior authority to an inferior authority. Delegation happens in a unitary constitution, where a superior authority, superior body, which is the center, delegates some of the powers to the inferior body, which is the state. But at any point in time, this power can be snatched. This power can be given to someone else. But in a federal polity, powers are distributed. Distributed by a written constitution, that these are the powers which are given to the center. These are the powers given to the states. Don't encroach into each other's space. Don't violate each other's rights. And this constitution, it should be a rigid constitution. What is a rigid constitution? Rigid constitution does not mean that the constitution cannot be changed, cannot be modified, cannot be altered. Rigidity does not mean that it is very difficult to amend the constitution. Rigidity means if constitution is to be altered, if constitution is to be amended, it must be a joint act of center and states. Five characteristics which make US Constitution a federal constitution, a federal polity. 1, Constitution is written. 2nd, there is dual government in place. One government at the center, the government in every state. 3rd, distribution of powers. Powers are distributed by the Constitution between center and the states, so that no authority is inferior, no authority is superior. Both have their own independent existence. 4th, rigid constitution. If this constitution is to be changed, if this constitution is to be modified, if some changes are to be made to this constitution, who can make changes? Only center or only states? No. Both center as well as states, they have to come together and to change the constitution, alter, modify the constitution. And lastly, independent judiciary. Let's say, for example, judiciary is like a referee, an umpire. If there is a dispute between center and the state, who will resolve this dispute? Judiciary. But if this judiciary is biased in favor of the center, then how will I take this decision? I will give every verdict in favor of the center. I will give every verdict against the states. Judiciary has to be independent, because an independent judiciary will impartially ensure that constitution is followed and ensure that this constitution is supreme. Supreme in the sense that neither the center can violate the constitution nor the states can violate the constitution. Supremacy of the constitution is paramount. And all these 5 characteristics, that is what constitutional experts say make US constitution a federal polity, a federal constitution. Where does India stand in all of this? Is India a federal polity or a unitary polity? Mix, both, mix, unitary, federal, unitary, mix, quasi. Okay. Let's look at India. Unitary constitution we know, but whether a constitution is federal or not, for that what do? We compare a constitution to the Constitution of United States of America. If it matches, then it's a federal constitution. If it doesn't, then it is something else. Let's match. Do we have a written constitution in India? Yes. A written constitution which was codified into various parts. Do we have a dual government in India? Yes. One government at the center, Mr. Modi's government at the center, and Mamta Didi's government in West Bengal. Yogi Ji's government in UP. Mr. Stalin's government in Tamil Nadu. Mr. KCR's government in Telangana. And if you read today's newspaper on front page, Mr. Modi says Mr. KCR tried to join NDA, but we rejected it. And Mr. KCR says, what are you saying? We never even volunteered to join your NDA. But be that as it may, dual government. Do we have distribution of powers? Yes. What is that distribution of powers? We have Schedule 7 of the Constitution. Schedule 7, it talks about union list, state list, concurrent list, which we will discuss in great detail when we will talk about center-state relations. But very briefly here, when we say distribution of powers, that means powers are distributed between center and the states. It should be mentioned in the constitution, right? Otherwise, there will be a lot of dispute. State will say, this is my power. Center will say, no, this is my power. It has to be mentioned somewhere. And where is it mentioned? Schedule 7. All those powers which are given to the center are part of this union list. For example, defense, external affairs, communication, banking, insurance, citizenship. It's all part of union list. All those which are the powers of the states are mentioned in the state list. That means these are within the powers of the states. For example, land, agriculture, gambling, so on and so forth, law and order, police. And all those items, all those powers, where both center and the state, both can make laws, these are part of the concurrent list. For example, marriage, for example, divorce, for example, criminal procedure, for example, education, forests. All these are part of the concurrent list, where both center as well as states, they have the power to make laws. So do we follow a written constitution? Yes, we do. Do we have a dual government? Yes, we do. Do we follow distribution of powers? Yes, we do. Do we have a rigid constitution and a supreme constitution? Clearly, constitution is supreme. Because Indian parliament is not sovereign. The sovereignty, complete, we'll say popular sovereignty is with the people. People have the ultimate say in a democracy. But constitution is supreme. Nobody can violate the constitution. And you might have heard, when GST was implemented in India, GST was basically a constitutional amendment, goods and services tax. When that amendment was made to the constitution, First, the bill was passed by both houses of the parliament. Then this bill was sent to all the state legislatures in India. Only when more than half of the state legislatures in India accepted GST, then this bill was sent to the president. Then president signed this bill. Then GST was implemented in India. Which means the amendment to the constitution must be a joint act of both center as well as states. If you want to change, if you want to alter, if you want to modify the constitution, it cannot be done unilaterally by the center. It cannot be done unilaterally by the states. It has to be the joint act of both center as well as states. For example, the GST, which means, do we follow the rigid constitution and the constitution is supreme? Yes, we do. Finally, fifth, do we have an independent judiciary? Is Mr. Dhananjay Chandrachud, the Chief Justice of India, independent? Yes. Are the judges independent? Yes. Do they give independent verdicts? Yes, they do. That means all the boxes are ticked. Indian constitution is federal. When Indian constitution is federal, but that is only at the surface. When we dig deeper, we see a completely different story emerging, where we say maybe Indian constitution is not entirely federal. Maybe there is something more than what meets an eye. And what is that difference? We will discuss after a break. Sure? So it is 7:45. We will meet at 8 a.m. and let's continue. See you on the other side of the break.